pillars of data privacy and protection in Nigeria. This is also to let you know that this meeting is being recorded, so I would like you all to sit back and enjoy. I don't know if everyone is here yet, or just like to go on. Okay, today we have 3 seasoned speakers that will be informing us on the various topics today on data privacy. We have with us, I can see Miss Sanni Fatima is here. Miss Sanni Fatima is a dynamic and highly skilled lawyer with passion for data protection and privacy. She is currently serving as a legal officer in the Strategy, Partnership and Communication Department in the Nigerian Data Protection Commission. And she's been recognized for her creative approach in organizing various workshops and training sections aimed at increasing awareness and knowledge of data protection and privacy in Nigeria. Ms. Sanni Fatima, please can you kindly introduce yourself? Or just say hello to everyone.
Hello, everyone. Good morning. My name is Sanni Fatima. I am a legal officer in the Strategy, Partnerships and Communications Department in the Nigeria Data Protection Commission. Thank you for having me.
You're very welcome. You're very welcome. Okay, we also have with us, I just saw her here. I don't know if she's still with us. We also have with us Miss Onyinyechi Nwachukwu, who is a lawyer with over 15 years experience in banking, non-profit sector and private practice, where she focuses on policy review, legal reforms and gender rights, as well as child protection and regulatory compliance. She is currently a partner at Heritage Attorneys. Please can Onyinyechi Nwachukwu, please can you say hello to everyone?
Hello, good morning. Good to be here. I look forward to having a very robust and engaging discussion with us today on the topic. Thank you.
Thank you very, very much. Our last and third speaker for the day is Olaoluwa Alokan, sorry if I mispronounced that. She's an alum of the prestigious University of Ibadan, and she has a keen interest in technology law, particularly in areas of cybersecurity and data privacy. She's currently a recipient of the CyberSafe Foundation Scholarship for Cybersecurity in 2024, and she's very passionate about her cause in women and children and mental health awareness. I don't know if she's joined us. Okay, she's not here yet. Okay, to get right into it, so we would not waste time, we'll be starting with Ms. Fatima Sanni, and she'll be focusing on the legal and regulatory frameworks and organizations' compliance requirements in Nigeria. Please, Ms. Sanni Fatima, over to you. Ms. Sanni Fatima.
Yeah, thank you very much, Ms. Chioma. So today I would be speaking about the impact of emerging technologies on data privacy in Nigeria, role and obligations of data controllers and processors. So when we speak about digitalization in its entirety, we cannot rule out the place of data protection and privacy. We know that it is a very crucial and integral aspect. To start up, I would be speaking about the overview of the Nigeria Data Protection Act. I would speak about the introduction to data privacy and protection, with emphasis on the legal basis for data processing, amongst others. So let me try and share my screen. Just a minute. Sorry, just a second. Okay, please, I may need to, it's saying I'm unable to share.
Hello? Hello?
Can you see my screen?
No, not yet. Hold on, let me fix that.
Okay.
Hello?
Just a second. I would
Yes.
mute my mic now and try and share the
Okay.
screen.
They use any of them now.
Okay, can you see it now?
Oh, yes, we can.
Okay, great. So I will start off by giving an introduction to data protection and privacy. So we know that data protection and privacy or data privacy has been provided for in our constitution, particularly section 37, which states that the privacy of citizens, their homes, correspondence, telegraphic conversations, and communications is hereby guaranteed and protected. Data privacy is more like a right that empowers individuals to make their own decisions about who can process their data and for what purpose. We can't have people collecting data without ensuring that certain measures are put in place to safeguard this data. And that's why we have data protection, which focuses primarily on the mechanisms implemented to safeguard data against access breaches and loss. Now, we have the Nigeria Data Protection Act, which is the current legal framework for data processing in Nigeria. The act was assented by the President Bola Ahmed Tinubu, which aims to regulate the processing of personal data in Nigeria and ensures the protection of individuals' privacy rights. It also provides for guidelines for the collection, use, and storage of personal data, including provisions for consent, data subject rights, which is very crucial, data transfers, and penalties for non-compliance. It addresses the challenges posed by emerging technologies and their impact on data protection. Of course, it's in fulfillment of Section 37 of the Constitution. Now, when we are speaking about data protection, certain principles have to be adhered to. And these principles are 6 in number. They include lawfulness, fairness and transparency, integrity and confidentiality, purpose limitation, storage limitation, data minimization, and accuracy. When we speak about lawfulness, fairness, and transparency, please, can you confirm that you can still hear me and see my slides?
Yes, I can still hear you and see your slide.
Okay, great. What slides can you see at the moment?
We're currently seeing the lawfulness, fairness, and transparency.
Okay, great. So what this principle says is that for you to process people's data, let me even provide more context. So before I go into the principles of data processing, let me now speak about key concepts. I know that this webinar is high level, but it is also very important to clarify certain terminologies that I'm going to be using in the course of this discussion. So we have data processing, which is the operations that are being performed on the data that is collected. We have data controllers that determine the purpose for the collection of the data. We have the data subject, which is an identifiable natural person. So for you to be an identifiable natural person, of course, what that means is that you can be identified. How can you be identified? By your name, your personal information, such as your name, your phone number, your email address, your house address, your BVN and the likes. So for this ecosystem to even thrive, there needs to be a collaborative efforts of key stakeholders, which is the data controller, the data processor, the data subject, and the data regulator. And one key take home here is that all the stakeholders mentioned are all data subjects, right? Your capacity would now, the capacity in which you are reacting would now determine your designation. So, I mean, a data controller can also be a data subject, or is a data subject, because of course it's represented by a data subject, because a company would not take decisions on its own, right? There needs to be human interaction. So it's a data subject that will still act as a data controller. The data regulator, which is the NDPC, is still made up of data subjects. And then we have the data subjects in the ecosystem. So now I'm going to come back to the principles of data processing. We have lawfulness, fairness, and transparency, which states that there has to be a legal ground required and linked to the purpose of processing. Transparency is the foundational right of a data subject. Do not surprise the data subject. So as a data controller, when you're collecting people's data, you need to ensure that there's a legal ground that is required for the processing of the data. It's not like you just go and then you just collect people's data and there is no purpose, right? You need to be fair. You need to be transparent. Don't surprise the data subject. Don't collect the data for a particular purpose and you're using it for another purpose. That's what that principle is talking about in summary. Then we have the purpose limitation, which is closely connected to the principle of lawfulness, transparency, and fairness, which states that prior to the processing of this data, certain things have to be determined. The purpose has to be determined, and this purpose has to be specific, explicit, and legitimate. So by legitimacy still links very closely to having a legal ground for the processing. It needs to be explicit, state it as it is. Don't hover around in a circle, or don't try to surprise in summary. It needs to be specific. Oh, I am collecting your data for record purpose, right? It needs to be clearly stated while you are collecting data. I mean, the course of the conversation, I would also speak about policies, and I would align the privacy policy to this purpose limitation as well. We have data minimization, which says that you should not collect more data than you need at the time of collection, right? So if I'm going to process anyone's data, I can't collect the data, more data than I need. So I would always use an example of a friend who wanted to get a store, and then she went to fill a form, the normal thing that is being done. And when they gave her the form, they were asking her for a lot of details, such as who her next of kin is, the job description of the next of kin, where the next of kin works, the phone number, which is normal, email address. I mean, that was just too much information, because we already know the essence of having or collecting details of anyone's next of kin, right? In case of emergency, the next of kin should be reached. So if you can contact the person through the phone number, why are you asking for job description, department, unit? That is a lot, and that is against the principle of data minimization. The data collected should be adequate, relevant, and limited to what is necessary in relation to the purpose for which it is being collected. So one thing that stands out amongst the principles is that they work together, they are connected, right? So it's saying that don't take more than required, and whatever you're taking should be relevant, right, to the purpose for the collection in the first place. And it should be limited. So here it says avoid duplication. Of course, you need to employ technical measures. When you are dealing with sensitive data, it's compulsory. You need to employ technical measures to safeguard the data. I should have also distinguished spoken about the types of data, distinguishing between the various stacks. So we have the personal data and the sensitive personal data, which requires more protection adequate protection, right? Because I mean, by sensitivity, we understand the word in its entirety already. So for the basic personal data, we have like your name, your email address, your phone number, your yes. Then for sensitive personal data, you have your health details, your religion, trade union, political affiliations, and its likes. I know that some might spring up some surprises in our minds that why is my, for instance, religious belief a sensitive data? We know that there are some areas that are particular to a particular that are not particular is not the word now, that are known, you know, or affiliated to a particular religion. So imagine being in a Christian community and then you are disclosing that you are a Muslim. We know the harm that could cause in some instances, stigmatization and the likes. Let's even leave the basic religion like Christian and Islam, right? Let's even think about being a traditional worshiper. And then you come and you just state it that you are a traditional worshiper. I'm sure some of us are on Instagram, and there was a time someone made a post, a popular person, and then she was showing like a video of when she went to the water and she had some animal over her. And everyone was like, why would you post that? Jesus is king, you know, things like that. I can tell you that if that person walks into a room filled with Christians, she's going to be stigmatized. And then she might just be, you know, people are very careful not to even go close to her and things like that. So it's very important to clarify and distinguish between the types of data. Then back to the principles, we have accuracy that states that data needs to be correct and kept up to date. How do you ensure accuracy of data? Verify correctness of personal data, delete or rectify incorrect data, update data at different stages, allow data subjects control of accuracy and rectification where necessary. And I believe I'm speaking to data controllers in the room, and it's very important to buttress this. I know that we just collect data. Sometimes, if you go to some places, they tell you to fill a form. Now, everyone has different handwritings, so somehow you might just mix it up, right? It's very important, especially when you have you ask for like a means of identification, sort of verify the correctness of the personal data. Don't assume, right? My name is Fatima Sanni. People think that, okay, because I am a Yoruba female, my Sanni is S-A-N-I.
I'm sorry,
It's
Fatima. I
actually
think someone is saying they can't hear you. I don't know. Sorry,
oh,
Oni, you can check your speakers, and maybe Fatima, you can try to speak a bit more loudly. And
okay.
also, we have like 20 minutes per session, but we'd like to give you like some extra time, so if you can just like quickly just
Okay,
take
okay, I
and
would be faster. So next is the storage limitation that speaks about not keeping data for longer than necessary. This is important. We know that certain laws have their storage, have like timelines in which you can store data, right? But don't store beyond that time. And if it's not necessary, don't store it, delete it or render it anonymous. In line with this, you should develop your retention policy, create retention purpose for different purposes, justify your retention period, consider anonymization. The principle of integrity and confidentiality just states that personal data should be protected against the risk of interference. Sensitive data requires more and adequate measures in place, more security measures in place. So I'm trying to run really fast so I don't take more time than I have been given. So in terms of accountability, which is one of the obligations of data controllers and processors, you must be able to demonstrate compliance with the NDPA, right? And there are some items that has been highlighted You need to document your processing activities, which is very important. I mean, if we have legal personnel here, you know how important documentary evidence is in court. And even before even getting to court, you know, if you have a document to prove, you are safer, right? It reduces the back and forth. Yeah. Then as a data controller, you need to appoint a DPO. The law specifically provides that if you are a data controller or processor of major importance, you need to appoint a DPO. So it's mandatory. A DPO is a personnel with expertise in data protection. The person needs to be certified. Thankfully, in Nigeria, we have just launched a national certification process. So when implementation begins, we can now start writing our exams and being certified here in Nigeria. So the big question now is, who is a data controller and processor of major importance? For time constraints, or due to time constraints, I would refer you to our website, www.nepc.gov.ng, to go through resources, and you'll see the guidance notice that clarifies who a data controller, a processor of major importance is. Then you need to engage the services of a data protection compliance organization. These are organizations that have been licensed by the commission. You need to maintain a breach register. Can we really eradicate data breaches? I do not think we can, but we can curtail and reduce it to its barest minimum. And of course, you need to adhere to data protection principles. Next, I would be speaking on the legal basis of processing. Generally, I think people assume that the only basis to processing data is consent, but the law has provided that there are 6 legal bases for processing. What that means is that where there is no consent, you can still process people's data, and no basis is superior to the other. They are all at par. So we have consent, where someone grants you explicit permission to process the person's data. We have performance of a contract, where, I mean, if we are in a contract together, you can process my data, where data processing is indispensable to fulfill contractual obligations. Legal obligation, where data processing is imperative for compliance with legal requirements. So if your law provides for it, you can go ahead and process data. For instance, in Smerdan, their act provides that they need to collect data of the SMEs under them. That way they can process their data without consent. Vital interest, this just speaks about the processing being in the interest of the data subject, which is everyone. So imagine somebody having an accident and then you need to save the person's life. You don't now need to, of course, obtain consent from the person. You can just go ahead and process data because it's in the interest of the data subject. Private interest, simple, in the interest of the public. Legitimate interest, I always say that it's in the interest of the data controller or processor. Then, most importantly, I would speak about the data subject's rights. We already said that data privacy has been provided as a right under the right to privacy under the Constitution, or in the Constitution under Section 37, but it did not break down these rights. The Nigeria Data Protection Act now has broken down these rights into several other rights, such as right to be informed, right to access, right to rectify, right to be forgotten, right to restrict processing, right to object to automated processing, right to data portability, amongst others. I will just quickly explain. Right to be informed simply states that, oh, I have come and you need to process my data. I have a right to be informed. In short, we recommend that, I mean, before the data subject even starts or wants to exercise that right, the data controller needs to inform the data subject. And one of the ways you can inform the data subject is through your privacy policy. Then we have the right to access. If you have collected somebody's data as a data controller, please don't hoard the data. The data subject has a right to come to you and say, okay, you have collected my data. Can I see? I want to access this data. It is their right, so you have to grant them. Right to rectify just means the right to correct. So in a case where you have collected somebody's data and maybe you have spelled it wrongly, which we always, I feel like that's a recurring mistake, especially amongst data control and processors, where you assume that it's spelled a particular way or this is a particular information. First things first, you need to verify the correctness of the data, as I already stated when speaking about principles. But now, if there is a mistake, it's the data subject's right to come to you and say, I want my data to be rectified. I want it to be corrected. Now, right to be forgotten. Okay, I have given you my data, but I'm not longer doing business with you. I do not want you to have access to it anymore. Forget me. Right? It's closely related to deletion and erasure. Just especially with loan apps now, when people, there is the term and condition that states, oh, when you sign up for our service, would have access to your contact. If I have paid up my loan, I can come to you and say, you know what, please take down my data from your system. Forget me. We had business, but we are not longer having businesses anymore. So I want to be forgotten. Right to restrict processing. What this simply states is that, okay, processing of data has begun, but I do not want it to proceed, right? So I can now exercise my right and say, okay, I want to restrict the processing. It should not be processed further. Right to object. I go somewhere and there is the part that says, oh, I need to collect your data. As a data subject, it's my right to say, oh no, I do not want you to collect it. That's an objection. Then right to automated processing. Of course, automated simply means that it is done with a computer. I would use an example to buttress my point on this. Imagine, let's say, for instance, the law provides that every DCMI, which is a data controller of major importance, should designate a data protection officer. And then by data protection officer, you need to have expertise, and you can develop that even after your basic education in terms of maybe your your university degree, right? So let's say I go to university and I come out with a third class, right? And a company is doing recruitments. And then when they are done, they are putting parameters, and such parameters can include, oh, if the person doesn't have a first class, you can strike the person out, right? It's a problem because now I am certified as a data protection officer, but because I don't have a first class, I have lost the job, right? But I can actually object to say, no, I don't want automated processing. I want to defend my skills. I want to defend my expertise. I want to have an interview, to prove my worth. So it's the data subject's right. Can we really talk about emerging technologies without cross-border data transfer? No, we can't. And that's why this topic is very, very important. Cross-border data transfer just refers to the sharing of data across countries or between distinct entities such as international organizations. Section 42 of the Act requires that the recipient of the personal data must demonstrate adequate level of protection for personal data, which is substantially similar to the provisions of the Act. In evaluating the adequacy of protection, NDPC would take into account the following: availability of enforceable data protection rights, data subject rights, existence of appropriate instruments, access of a public authority to personal data, existence of an effective data protection law, existence and functioning of an independent competent data protection authority, binding international commitments and conventions, membership of any multilateral or regional organizations. I'm just going to speak. There are some transfer instruments that needs to be in place when we speak about cross-border data transfer. Such transfer instruments include standard contractual clauses, the binding corporate rules, certification mechanisms. So if you have this in place, you can transfer data. You can transfer data even though the recipient country does not have enforceable data protection laws, rights, or even an independent data protection authority. Where all of this is not available, can data still be transferred? The question is yes. So the law in section 43 provides for an alternative in the absence of adequacy of protection. And this include the unequivocal consent of the data subject to the transfer for a performance of a contract, so benefit of a data subject, important reasons of public interest, legal claims, and of course, protect the vital interest of a data subject. I already spoke about this when we were speaking about the legal basis. Next is enforcement. Of course, for every breach, there is a consequence. Data subjects who are aggrieved by the violations of the Act by a data controller and processor can lodge complaints with the commission. I already stated that one important thing about the stakeholders is that everyone is a data subject. So even though the audience seems targeted to data controllers and processors, we're still data subjects. So if there has been a violation of the Act, please, you can lodge a complaint with the commission. You can just send an email to info@ndpc.gov.ng. I will display that at the end of my discussion. The NDPC is empowered to enforce the Act in the following ways: complaints and investigation. Of course, we receive complaints and we investigate, because even the law states that you are innocent until proven guilty. So we don't just take decisions upon complaints. We have the compliance orders, we have enforcement orders, offenses and penalties. I'll speak about penalties shortly. We have judicial review. If you're not okay with our decisions, you can take us to court. We have civil remedies, forfeiture, joint and vicarious liability. So as an employee, you can be liable, right? So it's not, let's not bear in mind that, oh, because I am the CEO or I'm not the CEO, if anything happens, my CEO is going to be accountable, nothing can be done, because I need to also buttress the point that as a CEO, you can actually be taken to prison just because of a data breach. So we all need to be careful. And that's why I'm going to speak about technical and organizational measures in the course of the discussion. NDPC can also issue compliance orders such as warnings, compliance with data subject requests, cease and desist order, enforcement orders such as remedy devaluation, compensation of the data subject, account for profits realized from the violation, penalty or remedial fee, and of course, imprisonment, as I spoke before. Forfeiture, the court can make an order of forfeiture against the convicted data controller or processor on individual in accordance to the proceeds of the Crime Recovery and Management Act. I've explained this. So technical and organizational measures, which is very important. So we have the technical measures, which include protection of data processing security that can be realized by physical measures or in software and hardware. Then we have the organizational measures that involve the implementation of instructions, policies, and procedures for employees to ensure that the security of processing of personal data. Of course, we know that we can put in these technical measures, but there can still be breaches, especially knowing that, technical measures are systems, right? They're the physical measures. How about the human beings? That's where the organizational measures come into play. So examples of the technical measures include encryption. It's very important to encrypt your data. We already know what encryption is about: access control, restrict controls as much as possible, data masking, firewall and intrusion detection systems. It's very important to put in systems that can detect attacks. Then we have the regular software updates. This is very important. It is important to keep updating your softwares. We have the data backups, right? Where is your data being backed up in cloud or physically? We have secure coding practices, endpoint security, data classification, and vulnerability management. Of course, we know that organizations can be vulnerable, but how are you able to manage your vulnerabilities? Then the organizational measures, we have the data protection policy, which is the privacy policy. This needs to be clear. It needs to be displayed in a prominent way. So don't have your privacy policy and you keep it to yourself. It's bad practice. And then your defense is, oh, but we have a privacy policy. The law already states that this privacy policy should be very clear and understandable. So a layman walks into your premises and they are able to read and understand and not just assume. We don't want policies that are filled with legal or technical jargons. And then another measure is to ensure that the data controller and processor has a data protection officer. I already defined what data protection officer is. It's very important because this is who would advise you or advise the company, right, regarding data protection and privacy. Employee training, we can't overemphasize this. Ensure that there is no weak link. As huge or as small as an organization can be, trust me, just one weak link and then there's a massive data breach, right? It is very important to keep training because this ecosystem is very dynamic. There are new emerging trends and there are emerging issues every time. So you need to stay up to date as an organization. It is very important. A data inventory, data privacy impact assessment. So before deployment, within, after, you need to ensure that you conduct a DPIA. It gives you the opportunity to access what you are even deploying. It gives you the opportunity to know the vulnerabilities. That is where you are able to detect them, right? Then we have the incident response plan. The law already provides that where the breach may likely result in high risk, you need to report to the commission within 72 hours. But within your organization, you need to have an incident response plan. How do you respond, right? If there is a breach, what do you do, right? And then we have the third-party risk management. Of course, we know that sometimes you need to engage third-party. Do you have your third-party agreements and the likes? Data retention policy, I already spoke about that earlier. We need to have the regular audits and assessments, and of course, privacy by design. This is very, very important. So whenever you are developing solutions, even within your organizations, at the point of at earlier thoughts, like when you are even thinking about it, think privacy. We are not, what this is saying is by design, you are designing and you are incorporating data privacy and protection into it. Then you have privacy by default, which states that while it's ongoing, privacy is still being considered. Obligations of data processors and controllers under the Nigeria Data Protection Act. I have just highlighted this on the screen. You can take a screenshot, even though I will share my slides when I'm done. Develop a data privacy policy. I've spoken about this. It is very important. When you are processing data, it needs to be in line with the principles of the NDPA. And that is why I started this discussion speaking about the principles, lawful basis, and rights of data subjects. So whatever you're doing needs to be in line with the principles of data subjects. Designate a senior officer as a data protection officer. So this states that, the law provides that you have a DPO, but we have stated here that it's a senior officer because we understand that this is very crucial, right? How is the DPO able to cascade this to management level? If it's a senior officer, it's easier, but we know how organizations function, especially public organizations, when it comes to cascading, right? If we're able to get a senior officer, then the management is aware of whatever is happening in the ecosystem. Register as a data controller and processor of major importance. We can't overemphasize this. Registration is still on to the 30th of September 2024. The guidance notice has defined who a data controller, processor of major importance is. It has also categorized it into 3 categories. We have the ordinary data controller, the ordinary data controller, the extra high, and then we have the ultra high. These categories are determined by the number of data subjects, that number of data that you process. So we have it ranging from 200 to 5,000, depending. And then the sensitivity of a data. Are you a multinational? Do you do cross-border data transfer and the likes? You can just read it up. And if you have any questions, you can send a mail to info@ndpc.gov.ng. penalties. I spoke earlier about penalties under enforcement. So the NDPC has the power to impose a penalty or remedial fee ranging from the highest maximum amount in the case of a data controller of major importance shall be greater than 10 million naira or 2% of its annual gross revenue in the preceding financial year. And if you are not a data controller of major importance, it shall be greater than 2 million or 2% of the annual gross revenue in the preceding financial year. The big one, emerging technologies. So emerging technology simply refers to innovative advancements or developments that have the potential to significantly change the way that we live. Examples are the AI, which enhances decision-making and automates tasks, 3D printing, which revolutionizes manufacturing by enabling rapid prototyping and customization. So as opposed to AI, we have the likes of ChatGPT and the rest, 3D printing, as opposed to going, if you have a child or your mother, as opposed to going to buy your kid a toy in a store, you can simply just come, design something, something very interesting, and then print it, right? And then it looks real to kids. We know how vulnerable they can be. Nanotechnology, very clear example is even the sunscreen we use on our face. Now I've moved to the current landscape of emerging technologies. We have AI for scientific discovery. We have privacy enforcing technologies. We have integrated sense and communication, quantum computing, blockchain technologies, and immersive technologies such as the VR, that's the virtual reality, and the augmented reality. So imagine wearing a device and everything seems real to you. Of course, you know that there's a lot of data that has been collected. So I get a lot of questions most times when I have to speak that, oh, don't we think that the whole data protection is going to stifle innovation? Or don't you think that there's going to be some kind of restrictions and the like? But I keep saying this, we are not here to stifle innovation. In short, the law even provides specifically in Section 5 that we would foster the development of technological solutions, right? Technological
Fatima, sorry. Oh, this topic is meant to be taken by Onyinyechi.
Oh, okay. So I guess I would, do you want me to, let me just share to the end. Do you want me to speak about any other thing or we are good?
I think
What I would just do is to align that with data privacy, right? I would align it with the impact on data privacy. Is that fine?
Everything before data and emerging technologies, that was your topic. So I think we would leave Onyinyechi to align data privacy with emerging technology. So if you can just round up.
Okay.
Yeah.
Basically,
Yes.
I have touched most of it. I have certainly highlighted on the obligations of data controllers and processors. And most importantly, I would recommend that every data controller here, or even if you're a DPCU, I'm sure that you have clients that data controllers and processors. So I would recommend that every data controller and processor of major importance registers with the Nigeria Data Protection Commission on or before the 30th of September 2024. Thank you very much.
Thank you so much, Fatima. That was very enlightening. That was I think I learned a lot. I can testify for everyone that listened. Thank you so much. Would be okay, sorry, I forgot to note. If you have questions, just drop them on the chat box. I would at the end of the session we'll read them out and the speakers would answer the questions. Thank you very much. Okay, on to our next speaker. I'm so sorry, we'll be rounding up soon. But on to our next speaker, Onyinyechi, who will be focusing on trends and impacts of emerging technologies of data privacy. I don't know if Onyinyechi is here. Okay,
Yes, I am.
While we're waiting for Onyinyechi, our last speaker just joined us, Olaoluwa. She already mentioned she's an alum of the prestigious University of Ibadan, and she's currently a recipient of the Cybersecurity Foundation Scholarship for Cybersecurity. Welcome, Alokan. So we'll be handing over the floor to Onyinyechi to speak on the impact of emerging technology and data privacy. Over to you, Onyinyechi. And Fatima,
Okay,
please, if you can share your screen as well.
yeah, fine.
So that, okay, so that Onyinyechi can comment. Okay, for the slides, and somebody already asked, yes, we'll be sharing out the slides via your emails after the session. Thank you.
I have stopped sharing my screen. Okay, great.
Good morning, everyone.
Good morning, Onyinyechi. Welcome.
Okay, so I'm going to be taking an in-depth dive through the impact of emerging technology on data privacy. I would like to simply define the terminologies, and from there, I would like to trace the history. Very often when we hear people say emerging technologies, we tend to think of AI, we tend to think of VR, like the first speaker was saying. But then if we trace it back from the history, we'll better appreciate the depth of what emerging technology is. So okay, so I'll start by defining what impact is. Impact is basically effects, influence. What impacts, what influence, what effect has emerging technology got to do? What effect has it had on data privacy? Cambridge Dictionary says to have a strong effect or influence on a situation or a person. Collins Dictionary says a sudden and powerful effect that something has on a situation, a process, or a person. And then when we talk about emerging technology, Winston and Strong defines it this way, and I think it came out as my best definition. Emerging technology is a term generally used to describe a new technology. So in this category, we could have AI, we could have the visual reality, we could have just name it. But it also adds, but it may also refer to the continuing development of an existing technology. For instance, nobody remembers we used to use typewriters. With typewriters, you don't need printers. As soon as you roll in your paper and you start typing, automatically you begin to get your feedback. You begin to see what you are imputing without needing to go through the process of now printing again. You didn't need screens. It was just there before your very eyes. And so because we've forgotten about typewriters, we tend to think of desktop as it's not emerging technology. We tend to think of laptop as it's not emerging technology. But the point I'm trying to make with that part of the story is the fact that it takes tracing history to recognize what falls into emerging technology. Let me dwell on this a little more by tracing the history of what we used to have in the banks and maybe in the health sector, the hospitals to be precise. Back in the days when you go to the bank, having bank accounts wasn't very common. Basically, the head of the home was the only one in most cases that has a bank account. And if maybe the mother works in one ministry or the other, then she has to maybe have an account. But most people were paid in cash in an envelope, brown envelope, white envelope. So they had no business with the bank. Everything was cash-based. You go to buy something, you pay in cash, no matter how much. The banks were always jam-packed. People were everywhere. Many of them with Ghana must goes, depending on the amount of money they intended to withdraw. The books were so huge. The ledgers, they were rectangular in shape. And the more they open it, the longer it filled the tables. And I doubt if anybody ever imagined going to those banks to steal those books. Think about it. Even if you stole the books and filled it in that, oh, I deposited 50,000 when maybe you deposited 5,000. The difference in the figures, the difference in everything would have made it very obvious that something happened. In fact, the burden of even carrying the ledgers will overwhelm you. And then it was usually written in multiple copies. So it was not, I doubt if anybody ever thought of stealing that. But then we had issues of cash thefts. I vividly remember a theft incident in my school, my secondary school, when the week we resumed and all our fees were paid in cash, and then a boarding house in the night, thieves came to the premises and then they tried to break the iron safe. Everything they did made it impossible. And that was when the idea of paying our school fees with bank draft came up. Now, why am I narrating this? I'm narrating this because it takes this history to be able to appreciate what we mean when we talk about emerging technology. It's not necessarily only the very big things. It takes even the little ones, the extra commas, the extra dots along the line of history to appreciate what we mean when we say emerging technology. It is also the development of existing technology. For instance, back in the days, X-ray was go there, pull your shirts, X-ray, and then you go home. And then that big folder that you have to put under your arm, and sometimes it's as tall as you, and then move from office to office for it to be read. But we don't use those anymore. Now the X-ray results are just there in the system. They are bringing it out. They are reading. Everything is so fast. Then we have MRI. Then we have CT scan. It keeps growing and growing when it comes to the health sector. But what point am I trying to make here? Emerging technology has various shapes and sizes. But the question we are dealing with in this session is, how are they affecting data privacy? Back in the days when you wanted to be X-rayed, you just filled your name on the book at the entrance of the door, and then you walk in, you walk out, you sign that, oh, you've been X-rayed. The same thing used to happen for most of the proceedings, but those things don't happen anymore. Hospitals are now using the hospital management system to do everything. The moment you walk in, then in those days, we used to have hospital card. If you are going to the hospital and you go without your card, oh, I'm sorry, you can't be attended to, because they have a long list of files they need to go through to find it, which they usually arrange alphabetically and things like that. And then when you come with your card, they see your number and then they go straight to the shelf where that number falls, and then they search and find your file. That was the common practice in the medical, in the hospitals. But now you just walk in and then what is your name? You tell them your name and they put it in and everything begins to pop up. So the discussion today is these beautiful things that make our lives easy, that we don't have to go back home when we don't come with our hospital cards, that we just walk into anywhere and then we quickly type and we quickly print in and everything is looking also beautiful. How are they affecting our privacy? And what concerns should this raise in the heart of those who control these things? We are the beneficiaries, the subscribers, what should we call it? We enjoy these things, the patients at the hospital, the clients at the bank. And then you imagine the comfort we enjoy when you sit in your room and you just press and your cash is gone and the person calls, I've received it. It wasn't like that back in the days. We as people who enjoy these new things, how is it affecting us? Are we thinking about the implications? And then the business owners who are keen about making us happy with every new development, are they thinking about the implication of this on themselves? We are happy today when we enjoy the quick service delivery, but tomorrow when we hear, oh, our data is in the dark web, it's being sold for £1, and then we go to court and sue and they have to pay fines. Are they going to be excited as they are providing these services to us then? And so are we invariably saying, do not, like the first speaker was saying, do not move in this direction to avoid the problems or the risk or the troubles? No, we are not saying that. We are going to strike the balance at the middle of where we are going to say this is direction to go and this is direction not to go. So I think with that introduction, we can come to the table with a better understanding of the point that is being made here. So the first speaker has already done a good job defining what privacy is. But I often like this definition that says privacy is the right to be left alone, freedom from interference or intrusion. Information privacy is the right to have some control over how your personal data is collected and used. Some control, meaning it may not be outrightly all you and you alone, some level of control. And then what are some of the real life examples of these emerging technologies? In the fintech sector, we want to look at apps. We all have apps on practically our banks. We have apps that we use. We have the laptops and desktop. I had to trace the history, so nobody wonders why is desktop and laptop there. We have network. Almost every organization has their network, where you walk in, you pay in, they'll tell you, hold on, network is down and all of that. We have the printers. I don't know if any of us heard of the Bank of Bangladesh that was hacked using their printer. The printer printed all through the weekend. And everybody was wondering, what's wrong with this printer? No, it wasn't the printer that was wrong. It was a very huge hack that was going on. We have our scanners. We have the websites. We have the fingerprint readers. We have the AI customer greeters. First Bank is one place where I've seen that you walk in and what's it called? The robot is standing at the door and say, welcome, what do you want to do? We have the ATM machine, the ones that dispense the cash. But then we also have the ATM card processing machine, the ones that actually produce your card and issue it to you. GTB Bank currently enjoys that. My last card was produced without anybody talking to me. I just walked into the ATM center and I imputed everything they asked me. And next thing, the card was vomited and I picked it and I walked away very pleasant. But then what's the implication of that? For that machine to be able to ask for my account number alone, and then automatically with my account number alone is able to produce an ATM card for me, it automatically means my account details is already somewhere in that system. That's the point we are trying to make. So many of these services are not possible if some or all of your data are not imputed to the system. Then I won't want to dwell so much on the data issues around fintech, because the central bank is doing a great job with issuing out guidelines almost every other week or almost every other quarter or almost as soon as anything comes up, CBN is quick to issue a new guideline. And then the Data Protection Act also makes robust provisions around issues of fintech. Even the Cybercrime and other Provision Act is also very keen about the bank and the fintechs, because this is where raw money is. But I think when it comes to health, yeah, we have some policies here and there, but I think a guideline that matches them back to back as much as CBN does with the fintech is not well enjoyed in the health sector, especially for us in Nigeria. So I would like to dwell more on the examples around the health sector and then the implications. So in the health sector, like I mentioned earlier, we have the MRI scan. Speaking to a radiologist, right? A radiologist, the person was telling me that before you are scanned using practically any of these scanners, from MRI to CT scan to ultrasound to X-ray, your data is fully imputed, because it is that basic factor that lets them know, okay, the person we are scanning is tall. So if maybe his leg is coming out with an imaging of, let's say, 2.9, it doesn't necessarily imply this, that. So they put those basic information there to serve as a guide into the reading of the final image that is brought out. And then I asked, so how do you safeguard this? He said, there's a password on the machine. There's a password. You just input the password, and the password, nobody else has the password except the officers in charge. And then the person was quick to add, you know, these things are not linked to the internet. They are just digital machines. So there's no fear. There are no issues of cyber attack on these things. Anyway, I'm speaking from a layman's point of view. Don't assume I'm trying to be a cybersecurity professional. That was what the person told me. And I said, okay, I understand your point, but I just want to understand from you what you know. And he explained in details. And I was shocked at that comment about, because the the machine is not linked to the internet, there's no fear of cyber attack. And then I asked, do you have routine trainings around data privacy and around cybersecurity principles and all of that? He said, no, we don't have such. The only thing they train us on is on how to use these machines. I spoke to a medical doctor and he had the same explanations and reservations. And then I was saying, okay, so how do you bring out the images from these machines? And they said they have ports like USB ports, you know, Bluetooth, where you just send the image out. You can even transfer it through WhatsApp. And then the machine is linked to a system like a laptop and things like that. And I was wondering, so how did they conclude that because this machine is not linked to the internet, they don't have any issues? I spoke to several of these professionals and they all had the same opinion. And when I asked the question, do you go through trainings from time to time to expose you to privacy principles, cybersecurity, hygiene practices? They said no, they are only trained on how to use whatever they need to use. And the truth of the matter is that when it comes to emerging technologies in this sector, it is almost a daily thing. Yesterday, I was speaking to someone, and then the person was telling me about new AI technologies that are being used for diagnosis, from the ones that use the voice sound to the ones that use one thing or the other, from contact with the patients to now diagnose various types of ailments. And the truth of the matter is that these are not going to stop. They will only get better, more frequent, and all of that. But we are not going to raise our eyebrows and say, don't do. We are only going to say, how do we safeguard ourselves while using these things? How do the users, how do the business owners ensure they don't get into trouble with legal risk while at this? NDPA now boldly issues fines. We saw some of those things come out, even though the names of those organizations were not mentioned. But in other climes, this is very common. The moment there's a breach, there's a fine, and then some businesses actually do go down because they cannot afford to pay the fines and then continue to run. You hear of employees being laid off because the company cannot continue to pay their salaries after paying such fines. So this is a win-win for all parties, both the beneficiaries and the business owners, to be able to say, how do we manage ourselves to avoid running into loss? We have the hospital management system, which is now very common. Most hospitals are using this now. It actually makes hospital operation very easy. You walk in, they put in your name, your file pops up, they send it to the doctor to notify him, oh, this patient is here and wants to be attended to. The doctor schedules you, you walk into his office, he conducts his consultancy and he's typing into the HMS, and when he's done, he makes his prescription and moves it over to the pharmacies and all of that. And then the pharmacist moves over to the lab. You know, at the end of the day, it's seamless. The client doesn't need to bother about holding any paper and all of that. As a child, my file in the hospital got missing. And then people are very excited about this, like, oh, this helps to ensure that client's privacy is preserved. So the client doesn't have to hold their files and then move from office to office and all of that. But then, speaking to one of the medical professionals about this, the person was emphasizing that this uses only intranet. It has no connection to the internet at all. So they also do not fear hacks. And then I spoke to one of the hospital management system operators, and he told me they use cloud to save the data they get through this system. So it implies then that the users of the system do not even understand how it operates. They don't realize that whatever they are imputing into the system is finally saved on the cloud. So this brings the question of the third-party vendor, like the first speaker was speaking. What kind of agreements are you having with your third-party vendors? Because at the end of the day, your third-party vendors are your data processors, meaning they have access to whatever data you are having. And then that also reminds me, When I asked the radiographer about encryption of the data being imputed into the various scanners, he said, no, they don't encrypt them. The moment you log in with the password, automatically you have access. So this shows how the multiplicity of our data in the hospital system, the MRI scanner, the ultrasound, the X-ray, every single device within the hospital system has a copy of the patient's data being managed by different departments at different times. While beautifully, the hospital management system works with a role-based access control, it is still not sufficient because automatically the data is on that portal. And then there is the tendency for third parties, for black hackers, for just name it, to have access. So we also talk about the laptops, the CCTV camera, which is one of the easiest things to hack. They are practically in every ward, just name it. They also have their website. Sometimes you go to the website and then patients' feedback are just, they are there. And it's just easy to track and get this information. Even the data of the employees of organizations are sometimes poured all over the website of organizations. They believe that putting the profile of their staff is a way of showing the strength of the organization. But then staff are also data subjects whose rights should also be protected. Then they talk about sending this data through WhatsApp, through printer, through telephone calls. These are data. Emails, AI surgeons, AI diagnostic machine, generative AI. So the point is that as long as the diagnosis or whatever the medical history being moved from place to place goes with the details, the PII, the personally identified information of that patient, which is indispensable in the medical system because you don't want to mix Caleb 1 and Caleb 2. Attaching their surname or even their middle name and other history will help you to ensure that, oh, the Caleb 1 you are dealing with today is different from the Caleb 2 you are dealing with tomorrow. But this calls for responsibility on the part of the operators. It calls for responsibility that cannot be negotiated. Why is this important on a one-on-one basis? The more people understand your medical history, the more you are susceptible to a lot of trouble. This is why a country like the US has the HIPAA. It's so straightforward. This is all about protection of the health data, no negotiations. While we may not have a clearly worded policy like HIPAA, we have, the oath that the medical professionals take at the point of being called to the profession, which deals with confidentiality, is way lower than the responsibility that data protection puts on them in that capacity. The extent of the data that is being collected now is way higher than what used to be collected in our manual files. Now, mind you, when we used to use manual files was not any better. Like I said, my personal file got missing in the hospital as a child. And then speaking to a medical doctor, they explained that, oh, sometimes someone just needs a file to conduct their personal research. And then they go to the file room, they request for a patient's file and they move it. Sometimes they go there, they take graphic photograph of the pages of the file they need and they move. But when you talk about privacy and teaching hospitals, I really do not even have an idea where to draw the line, where in fact patients are coerced into giving consent in the name of, this is how I learned. So these students are learning, they'll be your doctors tomorrow. So you need to accept for them to be a part of your diagnosing process because that's how they learn. It's a breach of the client's or the patient's privacy. Yes, it is. We understand the students need to learn, but then the patient needs to enjoy their right to privacy as well. And then we see things changing every day. And as they change, we need to change along. And that's why the principles, as highlighted by the first speaker, cannot be overemphasized. Encryption, anonymization, having very watertight agreements with third parties. We saw what happened last week with the CrowdStrike issue. That is a typical case of third-party risk. So where, let's say, the vendor who is managing your hospital management system has an attack, automatically your data on their cloud account has been attacked. And all it takes to know that it is your patients that are the victims is just knowing, okay, who are the vendors of this, who are the clients of this vendor? And once you are recognized as the client of that vendor, it automatically means that there's a tendency that your data has also been breached. So it is important that as health organizations pick up vendors, because I noticed that most of such organizations do not even bother to have an IT department or a cybersecurity unit. They rely heavily on the services of the third parties. Whatever they bring to the table is all they use. And they don't even take the pains to understand how the service they are enjoying from the third party works and what are the risk factors that they may suffer if anything goes wrong. The third parties are not willing to tell an outsider who just about everything they need to know. The few I spoke to just said, we don't give out such information. It's confidential, but yes, it's a software as a service that we render. Yes, we use cloud services. They don't even want to tell you what cloud service they use. But what if tomorrow you hear that Azure has been hacked, or tomorrow you hear that AWS has been hacked? If you don't know what cloud service your third party uses, then you're also in trouble. But these are the information that needs to be on the table at the point of contraction. So as we adopt AI tools, as we adopt emerging technologies in health, we must accept the reality of the fact that the data being collected to use these devices are a whole lot. And the loss of such data means a lot to both the patient, means a lot to the organization, means a lot to the third-party vendors. Since the third-party vendors may not want to pay fines, they may not go ahead to give you all the information, but it behoves on those contracting them to ask those questions and document them in what we call the service level agreement, so that they understand what their responsibilities are. I think, in summary, we must go ahead to move forward and make progress when it comes to adopting emerging technology. How we do that is to ensure that we adopt processes that we aid in mitigating the risk that come along with them, from third-party risk assessment to every layer of risk assessment, and then put mitigation strategies along the way. And also incident response plan. What do we do if this happens? What do we do if that happens? That way, we will be able to approach every scene or every incident with confidence, knowing that, okay, we already know what we want to do, and we go ahead to do them. Testing can never be overemphasized. Unless we test, we may never know. Like the incident that happened with CrowdStrike last week, it was just a case of someone not testing. So I think I have made my points. Thank you for listening.
Thank you so much, Ms. Onyinyechi. That was very enlightening. I didn't even know that, because when I hear of emerging technologies, I just go back to I think of technologies we have now. Like she mentioned, the AI and the rest. I didn't even know that we had to go back to when we were using typewriters and all the manual machines that are being used in the hospital today. That is very, very insightful, and I'm sure everyone gained a lot from that. Thank you very much. We're so sorry that we've wasted time. We'll definitely be done before one. Now we're going to our last speaker for the day, Olaoluwa. Like I mentioned before, she is a very she's very seasoned, and she has interest in data privacy and protection, and she also is a recipient of the CyberSafe Foundation Scholarship for Cybersecurity 2024 cohorts. Olaoluwa, will hand the floor over to you. Thank you.
All right.
Okay, can everyone hear me? Good morning.
Yeah, I can hear you, but can you like speak a bit louder? Your voice is a bit faint.
If faint, okay. Trying to project. Can you hear me now?
Yes, I can hear you.
All right, thank you very much for the opportunity to speak. My name is Olaoluwa Alokan, and I am excited to be speaking on emerging technologies and data privacy in Nigeria, and I will be focusing on can you see my screen?
I can see your screen.
Okay, awesome. Thank you. So I'm excited to be speaking to you all today, and I will be anchoring certain aspects of the discourse today. We have discussed at length Nigeria's data privacy landscape. We have talked about the laws that govern Nigeria's data privacy landscape, but I will be moving on to discuss the gaps in Nigeria's data privacy laws, comparing with other jurisdictions, what improvements can be made by the federal government when it comes to regulating data privacy and data protection in Nigeria. And also, I will be talking about Nigerian data protection and privacy case laws so far. And I will do a little bit on emerging technologies and corresponding data privacy laws in Nigeria just to wrap up. So without further ado, I will just move on to the next thing, which is the laws governing the Nigerian data privacy landscape in Nigeria. I won't be dwelling too much on this because I was listening to Ms. Fatima Sanni, who did justice to this aspect, speaking about the Nigerian Data Protection Act, which is now the principal legislation for data protection and privacy in Nigeria, which is such a welcome development. When I was preparing for this, I was telling myself that if I was preparing for this just a little over a year ago, it would be a different discourse, mainly because we only had the Nigerian Data Protection Regulation, which was a secondary regulation and was considered weak in many areas, not covering certain rights of data subjects. As the case may be. So the Nigerian Data Protection Act is such a welcome legislation, and it is the hope that, improvements are made as technology continues to evolve and as different needs for data privacy continues to arise. Like she also duly mentioned, it is also privacy is derived from the Nigerian Constitution. It's an inherent right for every individual, every citizen in the Nigerian Constitution. But it's also important to mention that there are other laws which, although are not principal legislations in Nigeria, there are other laws that, in some way or form cover certain rights of data subjects. When it comes to different areas, we have the Federal Competition and Consumer Protection Act, which is the act that governs the council, or the commission rather. And then we have the Consumer Code of Practice Regulations by the NCC. We also have the Consumer Protection Framework by the CBN. When Ms. Nwachukwu was speaking, she was talking about how the CBN continues to churn out guidelines, to regulate the ecosystem when it comes to data privacy, especially in the financial technology area. More can be done, but the CBN is doing a fantastic job. Also, we have the National Identity Management Commission Act, which, prescribes the measures by which identity is managed in Nigeria. We have the National Health Act, which, well, it's come a long way when it comes to health privacy in Nigeria, but there's still so much to cover, just like the previous speaker mentioned. And now I will be moving on to the gaps in the Nigerian data privacy framework using the EU as a case study. Now, you might ask why the European Union, right? But the thing is that from research over the years, many data privacy professionals will agree that the European Union continues to be the forward-leading continent, or the Europe continues to be the forward-leading continent in the area of data privacy across the world. So many other nations have gleaned from, their legislations when it comes to the General Data Protection Regulation, which was a breakthrough, by the way, in the Nigerian, in the data protection landscape, in the data protection scheme scene in the world, right? So I will be using the European Union as a case study because if Nigeria is going to improve, if there's going to be any chance at getting better, improving our data protection and privacy laws, I believe that the European Union will be a very great template to follow. We can glean from their laws. We can glean from how proactive their laws are, which we're going to see in a bit. But yes, that is why I decided to pick the EU as a case study. When you look at other climes like the United States, you look at Canada, many of them are very similar to what we have. What they have, the laws that they have are similar to what the European Union already has. And also you would realize that the GDPR is probably the most recognized privacy legislation across the world today. And so the EU proves itself as a very, very important player, right, in the data privacy and protection field or landscape, as you may have it. So Nigeria versus the European Union, right? Okay, so I already mentioned that in Nigeria, we have the Nigerian Data Protection Act 2023, which is a welcome development. There were so many things that were not included in the Nigerian Data Protection Regulation, which by the way, the Nigerian Data Protection Regulation is a 2019 regulation that existed by the NITDA. But, well, although it has not been annulled by the new act, it is great that we now have an act that helps to, would I say, so the Nigerian Data Protection Regulation is more of like was a weak legislation, basically. Oh, can I make my screen full screen? Okay, yes, I can do that. Hold on. Sorry. All right. I think this is full screen now. Can you see it's full? Is it full? Sorry. Okay. I don't think I will be able to share full screen. So sorry. Let me just share it the way that it was
Yeah,
before.
just share it like after the
Yeah.
session. Just
Share
this like on.
so that you'll be able to see properly. Yes. So, all right. Okay. So I believe you can see it as a full screen now. Can everyone hear me?
It's a full screen now and you can hear you.
All right, awesome. Thank you. So I was saying that the Nigerian Data Protection Regulation was what we had in Nigeria before the Nigerian Data Protection Act 2023 was enacted, right? And the act is such a welcome development because there were so many things that were not included in the regulation, which are now included in the act. And because the act is a legislation of the National Assembly, it behoves that it is now a legislation that actually governs data protection and privacy in Nigeria, right? And now but the thing about it is that Nigeria still has a long way to go flexible when it comes to statutes, when it comes to regulations that cover all the aspects of data that exist, right? So data is not just limited to health data. It's not just limited to financial data. There are so many ways in which data continues to evolve. And while the Nigerian Data Protection Act is a welcome development, it does not cover all aspects yet. And we will see that as technologies continue to emerge, we would still be needing a continuing improvement of the Nigerian Data Protection Act or other subsidiary regulations, to accompany the act so that there is a full-on enforcement of laws when it comes to data protection and privacy in Nigeria, so that you're not worried as a data subject, as an individual, about what aspect of your data is not protected by Nigerian laws. We want to come to a point where there is a full-on protection of every aspect of Nigerian laws. And it is possible, right? It is possible, and it is the hope that we will get there. In Europe, for example, we have the General Data Protection Regulation. I will not say that it is similar. I will not say that the Nigerian Data Protection Act is a similar legislation to it, but I would say that the GDPR, because the GDPR existed way before the Nigerian Data Protection Act came into force, but I would say that the Nigerian Data Protection Act draws a lot of similarities from the General Data Protection Regulation, and that is a very welcome development. Now, in Europe, we now have further laws that govern different aspects of data protection, data privacy, data subject rights in Europe. The Data Governance Act, for example, is something that I believe that Nigeria could do a lot with if we had a similar legislation that is. Now, the Data Governance Act in the European Union basically covers the data of the public sector, right? So, for example, in Nigeria, we have different ministries that handle data for millions of citizens. We have so many different kinds of commissions, national agencies that handle data for different purposes and have to, process this data and that have to process this data owned by data subjects, right? Now, the thing about it is that the Nigerian Data Protection Act does well to, cover a wide range of data controllers and data processors, as we have seen and heard from the very first speaker, Ms. Fatima Sanni. But the thing about it is that when there are specific laws to govern specific individuals, it makes for better enforcement, right? So the Data Governance Act, for example, in the European Union covers the public sector. The public sector in Europe, in European countries that have enacted and adopted this act, for example, are now guided by the Data Governance Act. And so they cannot act or process, they cannot process data, they cannot mine data, they cannot do anything at all with data without recourse to the Data Governance Act, which now makes it imperative for them to process data ethically, not just because they are public sector organizations or agencies that are dealing with big data, that are dealing with large data sets, but also because it is important for the government to lead by example. If the public sector is not adhering to data protection rules and is not adhering to data protection regulations, then what becomes of us, right? So it is the Data Governance Act was such a powerful legislation that decided to cover that area, in the European Union. Also, I'm going to talk about the European Union Digital Service Act 2024. The Digital Services Act, I'm sure you must be thinking, all these acts, what are these acts for? The thing about it is that the specific, the fact that these acts deal with very specific matters makes it easy, like I was mentioning the other time, that you want every aspect of your data to be covered. You want everything to be taken care of. And because of the multiplicity of these these laws in the European Union, right, you're guaranteed that every aspect of data is covered. They are leaving no room for any data breach to occur without the data controller being sanctioned. They are leaving no room for data mining to occur without adhering to the proper regulations. They're leaving no room at all for data subjects' rights to be mishandled or handled improperly. So we have the European Union Digital Services Act, which regulates, the digitization of, e-commerce, also goes on to regulate even some aspects of social media use as well. And then, covers in depth, right, the areas that the GDPR oversight would not even touch, right? Because that is the thing about laws. Data controllers would always find ways to circumvent laws. But when there is a law that continues to, that when there's when there are laws that continue to, touch in-depthly the specific areas of data subjects' rights, then we are guaranteed that we would be protected by legislation. We have the Data Act, and we also have the European Union Artificial Intelligence Act. Now, when I was speaking earlier, I spoke about how the European Union is not just a force to be reckoned with when it comes to, churning out legislations, when it comes to data protection and privacy, but they're also very, very proactive, right? The Artificial Intelligence Act will come into force in August 2024, where in July, meaning that they already have a law prepared to combat everything that, well, maybe not everything, because you can only foresee so far, right? But they have prepared a law that would be able to guide the use of artificial intelligence in the EU, and also among data controllers that would have any recourse to the European Union for any reason at all, which I think is particularly impressive because artificial intelligence continues to grow. We have so many aspects of it, machine learning models and things like that. And it is so imperative for these new emerging technologies to be governed by laws so that our rights as data subjects are continued to be protected. So I would now be speaking on what Nigerian courts have said concerning data protection and privacy, or what they will be saying in future, as we're going to see. So I have here the fact that in the 2019 case of Incorporated Trustees and the NIMC, amongst other people, there was the Federal High Court in Abuja, emphasized the need for data privacy, data security policies. And I think that this was particularly important because we need to know that the courts care about data privacy, data protection, data security. And the more these suits are heard in court, the more citizens are bold enough to, enforce their fundamental human rights, because we already said that privacy, data protection, all these are fundamental human rights that we should be able to enforce by what the Constitution says. Per what the Constitution says, right? And so the Federal High Court was emphasizing the need for, the NIMC to not just have data protection policies, because it is so easy to just have data protection policies and just have a written privacy policy somewhere, that you would be able to have recourse to anytime a suit comes up, but also to actually implement these policies. And what was the dispute in this matter? It was the fact that the NIMC, did not have enough security measures in place to, protect the identity of the complainants, of the applicants, right? And while they were not able to prove their case, the Federal High Court still emphasized the need for NIMC as a national agency, as a national commission, to make sure that its data protection policies are implemented and enforced, right? And also, in the famous case of the emerging market telecommunication services versus Mr. Eneye. In fact, Mr. Eneye has been a wonderful, wonderful party when it comes to the institution of data privacy suits in our Nigerian courts, for which we are grateful for. Precedents are always a lovely thing to have. And, the court also emphasized, the fact that data protection, data privacy is a right, it's key, and it is something that, we can always try to enforce. Now, I want to talk briefly on the fact that I want to talk briefly on the dismissal of the advertising, I forget the full name now, but Alokan is an advertising agency in Nigeria, and they had a suit against Meta at the Federal High Court very recently, I think about a week ago, although the suit was dismissed. Now, the issue that Alokan had with Meta, which we must be familiar with, I mean, if you use Instagram, you use Facebook, you use WhatsApp, then you know that the parent company for all of these LLCs is the Meta Platforms Incorporated, or incorporation. And Alokan had a suit against them that talked about the ads. The issue they had with them was the fact that Meta was using targeted ads, against Nigerian citizens, and so the advertising measures were unethical. Those were some of the issues raised. Although the court dismissed the case, for failure to prove these points properly, it is something to actually give thought to, that certain companies come into Nigeria, and because we don't have our laws, and because we don't have our laws duly enforced, because we don't have our laws duly enforced, they think that it is okay completely to just do whatever they like, as we are going to see in the next case, or in the next saga that happened on the 19th of July. The federal, sorry, someone's audio is disrupting. Thank you very much. So I have it here. We have the FCCPC and the NDPC versus Meta saga. And the NDPC is basically Nigeria's Data Protection Commission. And in conjunction with the FCCPC, which is the Federal Competition and Consumer Protection Commission as well, they launched an investigation against Meta in 2021, right? And the investigation was just about the fact that there had been certain complaints that Meta had breached our data laws, and that it needed to be rectified, basically. And so the FCCPC and NDPC now finally came to a conclusion about a week or two ago that Meta was in breach of certain laws, both contained in the FCCPA, that is the act that governs the FCCPC, and also the Nigerian Data Protection Act. And so Meta was fined the whopping sum of $220 million, and also $35,000 as reimbursement for the investigation launched into it and things like that. While we are yet to see how the case unfolds, some of the issues that were raised were the fact that Meta's privacy policy was breached laws in the Act, in the NDPA, and even in the NDPR, because the NDPA was not yet in force when the investigation was launched, right? And so the conclusion was that Meta was in breach and they needed to be sanctioned. Also, they talked about how Nigerians failed to have the right to self-determine their data, and also decide when they wanted their data to be used, to be shared across platforms. So because Meta handles both Instagram and WhatsApp and Facebook, it was found through the investigative process that, there was a bit of data sharing across these platforms, which is not supposed to be the case. And so so they were fined heavily. Now, while this is a final statement from the FCCPC and the NDPC, we are yet to see whether, Meta will appeal this sum or, file for a judicial review. But I believe that it is something that, is a very, very welcome development in Nigeria, to see that, the national agencies are taking our our data privacy very, very, very seriously. I think that's a wonderful thing, and I hope and pray that it would continue, to be like that, that when companies, whether international companies or even Nigerian companies, are in breach, that they are checked and the needful is done. Okay, so what can we look forward to? So I was doing my research and I just wanted to, know what are the things that we have talked a lot about emerging technology.
Olaoluwa, you have like
Yes,
5 minutes.
Noted, I saw your message. Thank you. So I was saying that, I was doing my research and I just wanted us to, have things to look forward to. We've talked about emerging technologies, we've talked about different laws, and it's so important for us to realize that the Nigerian government is actually working hard to protect our to protect us, to protect our data. And so the NDPA has the general application and implementation of the implementation directive 2024 drafts out, and the draft is supposed to be an add-on to the Nigerian Data Protection Act. So the areas that the act has failed to expatiate on, I believe that the NDPA guide like a GAID would be helpful in that direction. Also, the National Digital Economy and E-Governance Bill is something to think about because it completely changes the landscape of how electronic data is collected, of what kind of electronic data is collected. And if this bill becomes enacted as an act, it would now even become more imperative for us to take data protection seriously, because so many things, so many signatures, so many aspects of our personal data would be found on the internet. I wanted to talk briefly about emerging technologies, but I believe Ms. Nwachukwu has done justice to that. I will just mention privacy by design and talk about the fact that it is so important that privacy is not just something that we think about as an afterthought, but it is something that we build with, that when we are considering building as data controllers, as data processors, when we are considering building, we put privacy in mind as we do all of that. And lastly, I wanted to say that small progress is still progress. While we have seen the disparity in what we have in Nigeria and in the EU and how far we can still go, I believe that the progress we have made is something to be noted, and that we are all actors responsible for keeping our privacy intact. Thank you very much.
Thank you so much, Olaoluwa. That was really insightful. Thank you. I don't know. I asked earlier if anyone had any question, can drop it in the box, but we have just one from Onabanjo Abdulatif. I'm going to read out the question, then I think I would give it to Miss Fatima to answer. Okay, it says, what is the role of NDPA in a scenario where a researcher conducts research on vulnerable individual in a correctional center? The correctional officers were being interviewed, and in order for the researcher to counterbalance the view of the correctional officer from the inmates, the lifer inmates gave succinct, genuine view on the subject matter, which negates the statement of the correctional officer. During the feedback to the correctional facility, the officer in charge disagreed that the statements of the inmate should be expunged from the research findings because he can't allow such under his administration, even though data anonymity is strictly enforced by the researcher. Should the researcher delete such data? Is it possible that his attitude by the correctional officer could contribute to while most researchers don't give feedback to the research community? I don't know if that question is clear, but Miss Fatima, please.
Good afternoon, everyone. So this question is quite dicey. There is the place of data protection and privacy, and there's also a place of best practice, right? So you have gotten the consent, you're conducting a research, you have gotten the consent of the inmate, and the research is on maybe probably correctional services and all that, right? You don't want to indict. So you need to be careful of indictments, leveraging on, in quotes, rights of a data subjects or legal basis for processing data, right? So you can, I feel like if you can rely on public interests now, you can actually go ahead and process this data, but you have come to the correctional services or the prison, right? You have had an interview with an officer, and then you have an interview with an inmate. The truth is that to a large extent, there would be some disparities between their statements, right? And the chances are high that whatever you hear from the inmate would indict not just the government, but I mean the government, yes, but even the head of the correctional services. So you have to look at it holistically, right? I can't just speak on data privacy and protection, right? To be honest, because there might be a reason why the officer is saying, okay, expunge it. So the fact is, one, yes, there is data anonymity, which is now the data protection aspect, right? But it also depends if there's going to be indictment, because the fact that the inmate is already anonymous, does that take away indictment? That's another aspect, right? So if you are asking, oh, can I go ahead and process the data if I'm relying on a lawful basis, then I can holistically speak as NDPC. But I see that you are in line with the legal basis of even processing because there is consent. But there is another aspect of indictment. And remember, Nigeria Data Protection Law is one law out of probably hundreds and thousand laws out there, right? And there's something that they say in Nigeria, freedom of speech is guaranteed, but freedom after speech is not guaranteed. So you need to also take into cognizance the other laws that protect. I mean, now when I say protect as a human being, which is human rights, and then the organizations as well, So certain things, there's some information you cannot say. Even within my organization, it's not everything I can come out to say, right? But I will not say, okay, because, I'm a data subject, I would come out to say it. Remember, there's also something called oath of secrecy in public service. So there's public service rules. There are several laws that govern several actions. So it's a very, very dicey situation. But like I would speak now as a human being, it's very important to explore diplomacy in such things, because you don't even want to run into problems in the name of research, right? So it doesn't go beyond research to activism or something else. But there are ways you can go about it. You can also say same things, but they can be said in like 1,001 ways, and it depends on the reader who is reading it, right? So that's the thing about the question. But if the person who asked the question can sort of email me, we can discuss further.
Thank you so much. I think I kind of understood what you were trying to say, that while there's still freedom of speech, there's certain law under the public sector that does not allow you to say certain things because of public interest. So that's very enlightening. Onyinyechi, please, I would like you to throw more light on the answer to the question, like just like 2 minutes or so.
Sorry, which of the questions you want just to address?
Yes, please.
I think I didn't get the picture completely, but then we want to just emphasize the point that for every provision, there are limitations. So whatever it is you are doing, you want to be able to ensure that you don't go beyond the limitations. I didn't get the scenario that was painted, but I think that's the point.
I think the scenario is that a researcher was conducting a research, let's say in a prison, and
Okay.
we all know that the conditions of the prison are not so favorable. So most of the inmates gave reports that were not quite favorable. Then the officer in charge of the correctional facility stopped the researcher from putting out those reports because they were not fair and allowed basically. So the question is now asking like even though the researcher guaranteed anonymity, is it still like a reason why most of these researchers do not give their findings to the community because they are stopped from putting out certain information? And he was asked to delete the data. I don't know if you get the scenario now.
I think the purpose for the research should be clear from the onset. I work in the nonprofit sector, and most of the information we use to push for policies and projects are not exactly favorable. So if I walk into an organization and then I'm trying to collect data, for instance, the school feeding project, and then I go to a school and I'm asking the children, did you have lunch yesterday? And the children are saying no. And the teacher is saying I should scrap that information. I don't understand what exactly is the guiding principle. Do you understand the point I'm making? So the
Yes,
purpose for the research is fundamental. So if I'm trying to address a concern and you are telling me to either alter the information or tell a lie or not disclose, then it becomes a morality issue. So I think it is always important for the purpose to be clearly defined. So if the purpose is for the purpose of reformation, then the what's the point? The ugly truth needs to be told. Yes, some information may not be placed on the table to everybody. Yes, access control is very important. It's not every information I get in the course of research that I'll put out there to the general public. But then I need to identify who are the relevant stakeholders that need to hear this ugly truth. For instance, when it comes to issues around prison and prison management, we know a lot of things go wrong. We have Freedom of Information Act, which give people the right to even ask for information that, in quotes, are not primarily linked to them. So I think other provisions of the law can actually be activated to do the right things when the right things need to be done. But I don't believe that on the grounds of public service and on the grounds of data protection, the truth should not be told. No, access control might be a factor, but no, it shouldn't stop the truth from being told. I don't know the purpose for the research anyway. I like to emphasize that point, but I think it is important that facts are laid down as facts and then not painted for the purpose of giving a good dog a bad name or giving a bad dog a good name. Until we have facts, we'll not be able to carry out reforms. So for such research-based approach, it's just like saying you are carrying out a baseline survey that will inform a project implementation project, and then you say, no, don't say the way it is. Then if you don't say the way it is, then what will the project implement? At the end of the day, where the premise is wrong, the conclusion will definitely be wrong. So if the research is for the purpose of reformation, then the bitter truth has to be told us as to what it is. The best you can do is to put access control to the information being gathered in place. Thank you.
All right. Sorry, quick question for Fatima. Someone is asking when will the commission commence training for DPOs because she wants to become one. So she was asking if there's any training going on for people that would like to be DPOs. I think that will be the last question, then we'll round up the seminar.
Thank you. So I had mentioned earlier in the course of my presentation that we had launched the certification process, but we have not begun implementation. What that means is that training is yet to begin as well. But I would advise that you just follow us on our social media platforms so that when we begin implementation, you can be aware. But it will happen soon, but I can't give it dates right now.
All right. Thank you very, very much. I would like to thank everyone that joined the meeting. Most especially, I would like to thank our speakers. I cannot even lie. I learned a lot and it was quite insightful. The slides, like I mentioned before, will be sent to everyone after the meeting. We're so thankful on behalf of EdgeRise. I want to thank everyone that attended this webinar, and also our speakers as well. Really, it was really helpful. Same time next month, we hope that you will be able to join us for this insightful webinar. Thank you so much, and enjoy the rest of the day.
Thank you.